Good morning, everyone. I wanted to again welcome all of our attendees. We have both an in-person and virtual audience today. Our first panel is titled, Is Labor the Next Frontier of Antitrust? Our moderator is Noah Brumfield. Noah Brumfield is a partner at Allen and Overy's antitrust practice. He has over 20 years of experience addressing complex cross-border antitrust issues. He is a beloved teacher here at Berkeley Law, where he is teaching a class on antitrust and innovation. Professor Brumfield, I'll let you take it from here.
All right. Well, good morning, everybody. Thank you very much for coming here and listening to what I think will be an interesting and hopefully entertaining discussion of a really interesting and new area of the law for antitrust. At least it has been around for a while, but it's been a relatively quiet space in antitrust, and that's how antitrust interacts with the labor markets. So we've got an excellent panel here to discuss those trends and developments and some of the issues that we're seeing right now. I'll ask each of the panelists to introduce themselves.
Now it does. Yeah. So hello, everybody. Good morning. I'm Alan Ryan. I'm an antitrust lawyer, but and I now live in California. I'm actually a European antitrust lawyer. We moved over from Brussels 18 months ago, and I now work in Menlo Park. So I'm thoroughly enjoying the California experience. But just to make it a little bit more real for the students amongst you, I'm a real Irish American. So I'm originally from the USA, and we moved back to Europe when I was very young. And I was living in continental Europe at the time of college admission and applied to university in Ireland as a domestic student and was rejected as a domestic student, even though I was living in another EU member state. So I was going to be a test case at the European Court, but then I applied to the English Cambridge, which then let me in. I said, thank you very much. You can have your test case for somebody else. And I started working in London then, which kind of the natural progression of that, many decades ago. Originally, just for you, I originally thought I wanted to become a finance lawyer. I thought that was cool. At the time, this was, what was going. We saw Michael Douglas in the film Wall Street, etc. And then when I tried it, I didn't like it. And I much preferred antitrust, which I didn't know much about. But I liked it because it was actually the opportunity to be both an advocate and a corporate lawyer. And each case is different because you have to understand the market dynamics of each market that you are working in. So that's really a plug for the youngsters amongst you to say that actually getting a range of experience in different practice areas is something that I would thoroughly recommend before you really commit to something. Antitrust law in Europe is essentially federalized. Now, the federal word is almost a dirty word there, but the action takes place in Brussels. That's why we had the presentation from you, Mrs. Vestager, here. So I was in Brussels for several decades. So my natural audience is the European Commission. There's no difference as well, just to give you an idea, between in the USA, you're either an agency lawyer or a litigator. That's not the case in Europe. You do the administrative work in front of the Commission of National Authorities, and you do your own then court appeals. You only end up in court if you lose in the administrative procedure, or you are intervening on the side of somebody there. So I've done a number of European court appeals. The most recent one was UPS. We were prohibited by the Commission from buying TNT. We appealed that. We won. It was the first victory in a merger regulation appeal in about 15 years. And we'll see how Intel comes, but it was the first case where a US company was the sole appellant and won all the way up to the top court. So that's me. Let me pass it on.
Good morning. It's a pleasure to be here and a treat. I'm a graduate of Berkeley, and for about 16 months, I was on the Berkeley Journal of International Law. So this is really lovely, and thank you for the invitation. I graduated from Berkeley in 2006. Right away, I knew I wanted to do antitrust. And I kind of bounced around working for a judge for the Department of Justice in the Antitrust Division at Boy, Schiller and Flexner, doing plaintiff and defense side antitrust work. And I realized that I wanted to really focus on plaintiff side. So I lateraled to Lieff Cabraser in 2008, and I've been there ever since. I'm a partner there, and I founded what's the first, and I believe still the only, unfortunately perhaps, practice group that focuses on the intersection of antitrust and labor. We represent only plaintiffs and focus on almost entirely class action plaintiffs' work. So in this space, we represent workers against employers who collude to suppress their wages and other beneficial aspects of competition for workers. So thank you.
All right, good. I'm Kathleen Foote. I'm the head of the antitrust unit for the California Attorney General's office. You normally think of antitrust as being federal laws and federal enforcement, but there are state antitrust laws and state enforcement as well. My unit has grown from about 10 lawyers when I took over in 2003, and now we're about 25. So we're getting in, we are able to do a lot more, and labor is an area that really interests us. I happened to major in economics in college, which was at Radcliffe, which was then known as the girls' part of Harvard, which tells you something about how long ago that was. And after college, there were several years of misspent youth that brought me out to California. And when I finally got a job, it was as a paralegal in one of those large and now defunct law firms called McCutcheon, Doyle, Brown, and Enerson. And I happened to be working for one of the partners doing antitrust defense. And that was my first exposure to it. Ultimately, I realized that being a paralegal was not what I wanted to do in life. And so I did go to law school at USF and went back to McCutcheon as an associate, went back to USF as the academic dean, and finally got a job, a real job at the Attorney General's office. And although I hadn't been doing antitrust, was more looking into land use. They had an opening in antitrust, and I thought, well, I'll give it a try. And so I stayed on. Anyway, we have done several cases in the labor area and are deeply interested in it. I'll probably talk about one or two of them a little bit later in the program. It's a real pleasure to be here and meet with all of you.
Okay, well, thank you, everybody here. So we appreciate that we're speaking very much to a generalist audience. So we thought in discussing this panel that it would be helpful to really kind of set the framework for the discussion by talking about some general principles. So briefly, before Dean, I'm going to hand it over to you. I think for the audience, it's important to remember, particularly from my perspective, when I got into antitrust 20 years ago, I didn't think about labor markets. Just very simple. I thought about end markets where consumers are buying something, whether it's, I think we heard somebody ask a question about the semiconductor industry, whether they're buying semiconductors. Maybe theoretically you would hear about some monopsony cases where there's some monopsony power being exercised relative to a supplier. But again, the supplier, the input here was a product that was going into another product. Conceptually, yes, we were aware that antitrust could be applied to labor markets, but how that applied, when that was applied, was a pretty rare occurrence and not really well developed. Because when we're talking about antitrust, we're typically talking about product markets, products that ultimately somebody is buying and consuming at the end of the day. So Dean, maybe you can set the groundwork for us and explain your view of how the antitrust laws come into play when we're talking about a labor market.
Well, thank you. I'll just start with a very brief Antitrust 101. I think for the purposes of this discussion, you can think of antitrust in three buckets. One is the regulation of concerted action. That is agreements, coordination between different companies. There, the legal standard generally is whether the agreement, the concerted action, is on the whole anti-competitive. Different standards of review apply for hardcore violations. such as price fixing, the per se rule applies, meaning that if you prove the misconduct, if you prove the agreement, it's presumed to be anti-competitive and there's no further burden on the plaintiff. For other types of arrangements, such as joint ventures or vertical conduct, a much more searching rule applies, the rule of reason, where you don't just have to demonstrate that the conduct occurred, but that it's on the whole anti-competitive, usually in a defined market. The second bucket is single firm conduct, monopolization. That doesn't really come into play as far as I've been able to see so far in the labor context, but the standard there generally is whether you have market power, and if you do, you're a monopolist, and are you abusing that power in some way to the disadvantage of your competitors? That is, your success is not as a result of superior products or ingenuity or efficiency, but because you have rigged the market in some way. And we heard a bit about that this morning. For example, Google search preferencing its own products and services. The third bucket is merger review, when one company is allowed to purchase another. Standard there generally is that it will be allowed unless the merger is likely to substantially injure competition. And I think we'll talk a bit about those later on in more detail as they apply to labor. Until 2010, the antitrust laws generally were not applied in the labor context. And I think there are a variety of reasons for that. One is that for coordination among workers, that's generally a product of labor law unionization rules, which antitrust, there's an express exemption for most of that type of conduct on the worker side. There was also, I think, just a lack of awareness. I just don't think it was a priority. I'm not exactly sure why, for enforcers. Certainly on the part of companies, from what we have seen in our cases, starting around 2010, people in the C-suite of companies generally did not think that the antitrust laws applied in the labor context. And they would reach what they called gentlemen's agreements, and in one case, gentle ladies agreements, in the animator's case, where they would call each other up, the CEOs would call each other up and say, hey, let's just not compete for each other's workers. You don't hire mine, I won't hire yours. This was never the subject of an antitrust enforcement action until 2010. I think another reason, and we'll get into this in more detail later, was the dominance of kind of Chicago school ways of understanding markets, where perfect competition, though not a perfect fit, was the right model to use when understanding how markets worked. One of the great things in my view about antitrust law and what makes it so interesting to me is that it works in parallel with the progress of economics. That as research and scholarship in economics changes and evolves, so do antitrust laws. And so that's certainly true in labor economics, where a lot of new research has shown empirically in many different situations that basically every employer has market power over its employees, which has huge implications for antitrust. One example, to call out David Card from Berkeley, who received the Nobel Prize in economics last year, was in this space where he demonstrated empirically that increases to the minimum wage does not necessarily result in lower employment, which cannot be explained through models of perfect competition, that there's something else going on. So in 2010, this changed with an enforcement action from the United States Department of Justice that spotlighted what the DOJ alleged were a series of bilateral agreements among pairs of technology companies in Silicon Valley not to recruit from each other's employees. There were 7 companies involved, including Google, Apple, Lucasfilm, Pixar, Adobe, Intuit, and Intel, and Adobe. And because this was a new space, the DOJ stopped the investigation with an agreement from the companies that they wouldn't do it again. There were no fines, no penalties. And from that, my firm filed civil cases to represent the workers. We were able to certify a class of 64,000 workers nationwide from a variety of different job titles and responsibilities, from storyboard artists at Pixar who worked on the movies we've all seen, to hardware engineers at Intel. We're all part of the same class, which is a very unusual way for an antitrust case to proceed for reasons that I think we'll get into. Following that case, there are a variety of civil cases like that, challenging agreements among companies not to recruit each other's workers. One interesting one, I think, given where we're sitting, is a case against Duke and UNC, where the senior administrators of those two universities agreed not to recruit each other's faculty. One interesting development in the past couple of years is that the US Department of Justice has filed the first criminal cases, where now not just seeking to enforce this in its civil capacity, but actually seeking to impose criminal penalties on the executives who have engaged in these kinds of agreements. I think I'll stop there.
Okay, thank you, Dean. So Dean set out quite a bit, and we're going to spend a little time unpacking that. Kathleen, can you first speak to the California approach to non-competes as opposed to agreements between employers not to recruit?
Non-compete agreements are agreements that some of you may actually have seen. They're in quite a few employment contracts that people sign. And this is true of employment contracts at the executive level. And also, if you happen to be flipping burgers, you are very likely to see these things in your employment contract. When what it says basically is that if you leave that employment, you will not go to work for a competitor for some period of time. And if you do, you can be sued for breach of contract, damages, et cetera. Quite intimidating for many people. All around the country, these contractual agreements have been upheld, except in California. In California, California certainly has been very pro-labor for many decades. And the California legislature has spoken with regard to policy on a number of things that relate to labor. So California, unlike the rest of the country, has a law in the Business and Professions Code that says basically it's known as the Freedom to Work Law, and it says essentially that any contractual that any agreement that curtails the ability of someone to practice a trade or profession is to that extent void. There's another provision in the Labor Code that says that any employer that attempts to include or enforce an unlawful provision against an employee is violating the law. So, this is not actually an antitrust statute, although it's right next to the antitrust law, the Cartwright Act, which is California's antitrust law. So there's clearly a relationship. But the many things that you have to do to prove an antitrust case, you don't have to do if you want to invalidate a non-compete clause in an employment contract. You just have to go to the labor commissioner and complain about it. You don't even need a lawyer. It's a very different kind of thing. It's quite simple, and it is a policy statement that is enforced. Everywhere else in the country, and very much now at the Federal Trade Commission, there is a lot of thinking underway about having this be an antitrust violation. And if so, does it apply to everyone? Does it apply to a few people? How do you define the market? There are many, many antitrust concepts that sort of go into it. But in California, it's different. That said, there are a great many people who in California who still have those things in their contracts. I want to mention in this connection a sort of an interesting phenomenon about, gosh, I want to say 25, 30 years ago, there was great interest in the difference between the dynamism of Silicon Valley and the relative lack of dynamism of what's called Route 128, the tech corridor between Boston and Providence. And study was done of every single thing that could possibly be a variable and what might be different. And what was discovered was that on Route 128, the companies there, people stayed in the same company for about 13 or 14 years, whereas in Silicon Valley, people would leave within less than 2 years. Very striking difference. There were other studies that also found that what people would do when they left a company in Silicon Valley is they would go work for a startup. They'd go work for either an existing competitor, or they would start their own company. So there was a lot of new entry in all kinds of areas. Whereas in Route 128, if people had new ideas, they would try to effectuate those within the company itself. So there's some very significant differences that it is thought may well flow from this very different approach to non-compete agreements affecting employees. I'll stop there.
Thank you very much. So just to go across the pond, I think the fundamentals on antitrust and labor are the same as in the USA. The antitrust laws apply to labor markets like they apply to any other market. The issue really is enforcement, and there's a couple of differences in the detail on the institutional framework that account for the difference in enforcement. The first one being that, as we heard from Mrs. Vestager, the EU you have the European Commission, which is but it works very closely with the national competition authorities of the member states. Different member states have different traditions, different frameworks, different legal systems, right? I mean, the pub quiz question we're going to have at the end of this is how many common law jurisdictions are left in the EU, okay? But it's more than one, et cetera, et cetera. Most EU countries have a tradition and still have significant collective bargaining, which means that the industry, basically the bosses, the companies negotiate with the unions in each industry, and you have sector-wide pay agreements. And that's there. And those are obviously exempt from the antitrust laws and have been ever since the beginning. They've been a feature of these countries for decades, even centuries. That's it. As a result, there's been limited need to have antitrust enforcement when it comes to most workers in most European countries. That's not true there for some. The obvious one, which is no longer in the EU, was the UK, but the UK obviously didn't have that to the same extent. Other countries are, the further north you go, the less you have it, basically. But that means then that the European Commission itself is less motivated in enforcing it. As a result, the enforcement has been at the national level. And there's another difference with the US, which is these are, with the exception of Ireland and Sweden, these are administrative systems. They're not law enforcement systems, they're administrative. So you have the government, and then you would typically have a non-antitrust person in charge. So Commissioner Vestager is not an antitrust expert by background. She is obviously an expert now, but when she started, she wasn't. She's a politician. At the end of the day, she gets to set the political tone, and the tone that she set is very much, I want to have fair markets that work for everybody. I think she's well ahead of her time in having figured that one out. As a result, she's actually the most popular politician at European level by a long way. Had she been president of the European Commission at the time of the Brexit vote instead of Jean-Claude Juncker, she's the type of person you could put on a TV platform in the UK. Who knows how the referendum result would have gone differently. You know, life is full of what ifs. But you have this, as a result, we now are starting to get private enforcement, but these are typically damages cases that come after the agency has found a practice to be illegal and has set the fine. So we don't, unfortunately, have people like Dean. We need people like Dean. They are coming, but we don't have them yet to protect the individual worker on that. That said, it's definitely there. And as you do, since the laws do apply to labor like any other market, at times of crises, you do see increased enforcement. So in 2010, coming off the back of the financial crisis, you had a couple of cases in France, in Spain, in Germany, in the UK of action. So the Spanish, for example, took action against restricted practices for hairdressers, for example. Then it all went quiet until the current, basically, crisis, where I think most people have realized Brexit was a real wake-up call in the UK. My analogy of Brexit, it was the February Revolution, essentially. Economically, you can say it's an irrational vote for the UK, but for individual people, it was a it's not an irrational vote. Freshfields' biggest office is in London. You'll have the same thing. Any law firm in London, any bank in London, if they're being honest with you, will tell you that the majority of their professional staff voted Remain because it's good for business. The majority of their staff voted Leave. Anyone who's obvious, anyone who's being honest with you will tell you that. So we are now in a situation where a critical mass of people don't think that the market as we have it now is giving them the results that they want. Wake up call 2016 across the EU. And it's not just a question of a few tens of thousands of industrial workers in Pennsylvania, Michigan, and Wisconsin who can, determine an election. They're really just the tip of the iceberg. So there's an issue there. So since we've had a number of decisions coming out of national authorities in Europe, not the European Commission. Again, there's a kind of a healthy competition between the national authorities and the European Commission on who's going to be the trendsetter. Here it's the national authorities. And the classic one is Portugal. The thought leader in Europe now is Portugal. And it's actually quite telling. So is anyone in the audience Portuguese? No. Okay. So we can learn a lot from Portugal. We can learn an awful lot from Portugal. Portugal is a country that, along with Ireland, suffered tremendously in the financial crisis in 2010. Portugal reduced the number of citizens who were subject to collective bargaining agreements by 80%, I think, right? Even Mrs. Thatcher got nowhere near that. As a result, Portugal had to adapt the system. So the Portuguese Competition Authority is the one that's now coming out saying, right, we don't have collective bargaining, we've got to apply antitrust laws. They've come out with a number of very good thought leadership papers, and they are the most active in enforcing this. So the first thing was in what we call football, right? Soccer over here. Women's football, there was an attempt to have a salary cap. Portuguese authority said no. The other one then that they did was also football. For the Division 2 and 3, there were no poach agreements. They said, no, we're not talking about Ronaldo here, right? Somebody who earns hundreds of millions. We're talking about people in Division 2 and 3 who don't earn much money and who go and play in the rain, etc., on pitches without a blade of grass on it. So Portugal has really been setting the trend there, and they've come out with a number of very good ones. They've also been following California, which is very interesting, because they say in their background papers that California, essentially they say jurisdictions which have a strict approach to non-compete, they're talking about California, have much higher levels of innovation and investment in employment, investment in people as well, because you've got to compete to keep your people. And therefore they are suggesting that in the merger context, for example, non-competes, company A buys company B, the buyer is protected, so the seller then agrees, I won't try to poach the employees, and so on, saying, typically that's been allowed for 2 or 3 years. The suggestion is maybe we should come closer to California on that, but that's very much the issue. So really the thought leader, the other countries that are following the Portuguese example are Poland and Lithuania, also in the sports field, but that trend is there, and very much they know that if where collective bargaining is weakened, then antitrust enforcement has to step up, basically. Otherwise, we've got a powder keg, basically. So that's the difference. I think those are lessons that, frankly, they apply across the world.
Okay, thank you, Alan. Thank you, all of you, for that background. And I think that does set the tone a little bit for why we're talking about this issue. But maybe we can go back to something that has been evolving in the courts. We have an explicit exemption for unions to allow them to organize without worry about the antitrust laws and how the antitrust laws apply. But maybe, Kathleen, you can talk about the implied exemption that's developed as a result through the courts and explain how that relates. and specifically, there's a recent decision now, the Ninth Circuit decision involving California versus Safeway on how the stores would collaborate in terms of profit sharing in response to a union strike.
Right. Okay, fairly recent. Don't know if any of you are from the LA area, but those of you who are may remember when you were young that in 2003, 2004, there was a major strike of the workers at the large supermarkets. Safeway, Vons, Albertsons, and Ralph's were part of what's called a multi-employer bargaining unit, bargaining with the UFCW on all the usual things. And it turned out that what they had on the side was an agreement to share revenue, or actually share profits, if there was a strike. And the reason that they wanted to do that was that what unions frequently do is they do what's called whipsawing the companies, and that is they'll strike selectively, or they'll picket selectively. One company is then worse off than the others. Well, when you think about it, I mean, obviously the employers want to protect themselves against that. That's a level of pressure that figures in how quickly they will reach an agreement and yield to what the unions want. But think about it a little further. There's the labor market, but then there's also the product market. So what happens when they agree that they're going to share profits, that they're going to share revenues? If one is being picketed or being struck, obviously it's losing revenue, and well, it's being shored up by the others. But aren't they supposed to be competing with one another on the product market? Shouldn't this be, if anything, an opportunity? If there's a picket line out in front of your competitor's store, this is an opportunity for you to get some more customers in, maybe ultimately permanent customers. So this is one of those frequent situations where what happens in the labor market really does also impact the product market. But this is an issue that comes up, you know, as Dean has said, very rarely, very few cases on it. Our office decided to sue. We did so because we felt that it was, because of the impact on the product market, it was an antitrust issue. And not only that, it turned out that that of the companies that were part of this in the open, there was the multi-employer bargaining unit that was agreed on by the union, but there was yet another company that wasn't part of that, that was a subsidiary of one of the three, that had also agreed to participate. And ultimately, it turned out that that company was the one that was making all the money during the course of the strike, which went on for 5 months. It was a huge issue, and it affected a great many people in the LA and even San Diego area. So the big issue was, is this exempt because it involves collective bargaining? Collective bargaining, by and large, is regulated by the National Labor Relations Board. But the National Labor Relations Board didn't want to touch this. This was not technically part of its area. It was not wages, hours, and working conditions. It was not the kind of fundamental agreement that had to do with the fundamentals of labor. So, so that was the significant question. And what the court found, two trial courts found, and then eventually the Ninth Circuit twice found, was that this was not exempt from the antitrust laws. And the reason for that is that it extended, well, they didn't mention the fact that it wasn't regulated by the NLRB, but certainly that was an underpinning of it. but it was not one of the mandatory subjects of collective bargaining. And it was an agreement that affected the product market. The fact that it affected the product market was the key for them, because that really brought it into the antitrust realm. However, they weren't willing to say that this profit pooling agreement was per se unlawful, or even something very close to per se unlawful. The three judge panel at the Ninth Circuit did think that it was pretty close to per se, but it went to a rehearing en banc, and the 11 Ninth Circuit judges decided that it was not, that it had been for a limited time period, it was too novel, impact not predictable, and things of that kind. It's very interesting, because had it not been for the fact that it was collective bargaining, it would have been clearly, this kind of thing had been since time immemorial treated as a per se unlawful agreement affecting the product market. Going way, way back, even before there were trusts, there were profit sharing, profit pooling agreements among companies. In fact, because there was so much difficulty enforcing them and there was so much cheating, trusts were kind of invented as a way to enforce a little bit better among the agreeing companies the terms of that. So it's interesting that the courts in this case, despite the potential, certainly, and theoretically immediate impact on the product market, were very hesitant to just sort of go all the way and say, you just can't do this ever. But they did say that it is not exempt. And that was a key ruling. That was a key ruling for labor in general. In fact, this particular scheme was one we learned in conference with the judge, we learned was ready to be implemented all around the country until, of course, it was determined not to be exempt. So that's my story on that one. I will also say that with regard to unions, it's important to remember the weakness of unions that has developed over the years and how very strongly that has affected everything in this area, unlike the Europeans. I think I saw a statistic that in 1973, 24% of private sector workers were unionized, and 4 years ago, only 6.5%.
Thank you. So you've raised a number of points, and I want to follow up on something that Dean had mentioned earlier, and that is really that we're dealing with are some really novel issues. Before 2010, I think what I'm hearing is that mostly we would agree that antitrust generally wasn't applied to many of these issues that we're seeing today. Antitrust laws have been around since 1890, though. And we have rules generally, as Dean was describing, that say that certain agreements are per se unlawful when there are clear violations, when they cause clear harm in the market and to consumers. And other than that, we generally apply what's called the rule of reason, which allows you to balance the effects in terms of trying to understand the justifications against the actual competitive effects. So I guess one critical question we have when we're talking about labor markets as distinct from traditional product markets is there a difference between the two? And does that difference warrant different treatment in terms of thinking about these types of agreements? Now, maybe you might say that there's an approach to pure wage fixing. But even then, if you have unions who are governed by federal labor law or state labor law, and you have others, is there still a difference there to the antitrust rules that should apply in these circumstances? Anybody? Dean, you want to kick it off since you had started this issue?
Sure. So to contrast labor with products, I think maybe it makes sense to start with products, which since its inception, it's where antitrust has really focused until recently. And so think of, for example, breakfast cereals. If there's an agreement between two competing brands of breakfast cereals to coordinate in some way, one of the questions an antitrust lawyer would ask to assess the anti-competitive harm is, from the consumer perspective, does that agreement limit choice? Or can two companies that get together, say if it's just blatant price fixing, agree to increase the price of two brands of breakfast cereal? Would that actually have an effect in the marketplace? Would prices actually go up? And so consumers go into the supermarket, you see an aisle of, nowadays, I don't know, 200 or so brands of breakfast cereal, and you notice that two of them are 5 cents more. You shrug your shoulders and you grab, shredded wheat instead of Lucky Charms or something. Now compare that to the employment context. Okay. For the law students here, imagine you're just, reflect for a moment on the amount of time and effort you are putting in to your first job after law school. That is not choosing between breakfast cereals. Okay. It's a dramatically different thing. In my view, there's universes apart. In social surveys where people are asked to rank the most traumatic events of their lives, being fired from a job is right up there with the death of a family member and a divorce. And why is that? There are so many ways in which the employment relationship is very sticky, it's strong. Once you've committed to an employer, all kinds of consequences flow that do not occur in the product market. For example, if you switch your employer every 2 months, pretty soon no one will want to hire you. You'll hand in your resume and you'll demonstrate how much you're moving, and the employer will say, why in the world would I hire someone who's going to be gone in 2 months? You compare that again to breakfast cereals. You can try a different breakfast cereal every day. You're never penalized for it. So there are all kinds of differences there. One big one for antitrust purposes is what I alluded to before, which is that so much recent scholarship has demonstrated that every employer in the economy, from law firms to fast food, McDonald's locations, have market power over their employees. And what does that mean? What that means is that employees are not constantly paid their marginal revenue product, meaning, you're not always paid how productive you are. As we've seen in the economy, and this is a big public policy issue, that with the retreat of unions, with the enforcement of arbitration clauses, which prevent any real civil remedy for all kinds of worker abuses, as companies have become much more productive, as workers have become more productive, their wages have not kept up with their productivity. And the reason for that, of course, is that if the workers are not receiving the benefit of their productivity, it's going to the employer. So the share of productivity has moved in the employer's direction over time. So one kind of thought experiment, which a professor who's at the forefront of this, Alan Manning, at the London School of Economics asked audiences, is imagine if you worked for an employer and that employer said, times are tough. We're going to have to trim salaries across the board by 5%. And we hope that next year we'll be able to turn it around, but this is the only way that we can stay in business. Now, if you were a Chicago school, acolyte, and that's the way you saw the world, what you have to predict at that moment is that every employee will immediately quit, and every employee will immediately find a job without, worthwhile or remarkable cost somewhere else at the old wage. Of course, that doesn't happen, and that means that employers have market power. So why is that so important for antitrust? Well, it's how monopolists are defined. If you have market power, you are a monopolist. Now, I don't think we want to treat every employer as a monopolist, but that's one potential implication of this. For agreements that restrict competition between employers, if every employer has market power, that component of the analysis, if you're under the rule of reason standard, is satisfied. If you accept the logic, the basic reality of how labor markets work, that should not be, in my view, a requirement to show a violation. Now, there's a great degree of debate over this, and that the implications of that in terms of the application of antitrust law right now are being litigated in 10 or so cases around the country, from the aerospace industry to franchise workers. So those are some of the main differences.
Okay. Alan, do you see differences that warrant different treatment?
The answer is yes and no. It's a typical lawyer's answer. And the answer is no, there's no difference in the sense that labor is a cost, and antitrust has always had a particular approach to cost. So essentially buying cartels, they haven't been, but buyer groups have always been subject to much more lenient standards, across the world than seller agreements, simply because the expectation is, well, it reduces costs, therefore it promotes efficiency, etc. So labor is part of that. And the Portuguese Competition Authority, when they came out with their seminal guidance, they actually rationalized this and saying, look, this approach is entirely consistent with classic antitrust approach. So that's the no, there's no difference. But then, yes, there is a difference because people aren't just cost. And, we can all philosophize and get political and ask ourselves the question whether part of the reason why the world is in such a fragile state now is because until recently, we have treated people as costs. Maybe it's a question. It's a question on that. But there's really the question of who are the antitrust laws there for? And you take in, some people will say, I know in the US, they say the Chicago School is consumers. And Mrs. Vestager will say, yes, I'm working for consumers, but there's no point in getting consumer prices down if those same consumers' net wages go down even further. They're not going to be happy with the situation, and that fundamentally is what it's about. And then following on, Dean, so there's been a lot of studies which the policymakers have taken account of, which show that inter alia, the share of worker remuneration as a percentage of GDP has been going down. Workers have been taking lower wages and more of the risk, and that benefit has flowed disproportionately to shareholders. Okay, now whether that's a good thing or a bad thing, we can debate, but it's a debate that we ought to have. And then you go back to the question about, okay, well, what's the antitrust law? Fundamentally, there's a balance here because, we say, well, in Europe, you don't have to worry about it because there's the labor laws, et cetera. I think there's loads of research that shows that where the labor laws are too rigid, it blocks job creation. It definitely blocks job creation, and it blocks economic, it blocks innovation, it blocks advancement. There is a balance to be had here, but fundamentally, at the end of the day, we're talking about citizens. We're talking about antitrust authorities that are by and large led by political appointees who are there to deliver a result for the citizen. And that's, I think, what makes the labor market more different. If citizens' wages go up and consumer prices go down, then pretty much everybody's happy at the end of the day. That's the ultimate debate. What's the purpose? Now, I know just the final, so as I understand it, part of the reason for the Chicago School becoming popular was there was a concern, not just in the USA, but elsewhere, that North American and European economies were losing ground to Japan at the time, right? This is the 70s and the 80s. Japanese industry was so much more efficient than European and US industry. They took it and said, well, maybe we're becoming too soft. We need to reinvigorate our economies, et cetera. And we did. The economy certainly got reinvigorated. Now, of course, we have different strategic competitors on that. But fundamentally, the question is, where is the balance between having a happy and fulfilled citizenry and an efficient economy? I think that's what makes labor special.
Okay, maybe following up on that point, Alan. In the past summer, President Biden issued an executive order dealing with antitrust issues across a range of areas involving agriculture, technology, but also labor. And one of the points that he specifically directed the FTC to address is whether or not non-competes should be regulated in some respect, vis-a-vis employers and employees, along the line that Kathleen talked about earlier. But notably, the executive order doesn't ask for the FTC to ban them outright. What is the right approach if you're going to the FTC and trying to get them to regulate in line with the executive order?
I think the California experience it militates in favor of a decision that those kinds of agreements are more anti-competitive than not. However, I will say that one of probably the biggest problem in this entire area is a lack of economic study. There is now a whole new wave of it. Dean referred to some of it. There's a whole kind of a younger generation of economists that have huge data banks, and they are generating some really important studies. But a lot of the information that, unless there's going to be just a plain vanilla policy statement, such as the one California has, I don't think that it's within the realm of feasibility for that to happen on a national level. There are several states that now have done what I think the FTC may be considering, which is to ban non-competes for low-wage workers. These are shocking, really, that if you work at Burger King, you have a non-compete that says you can't go to get a higher salary with a higher pay working at McDonald's, or that if you work at Jiffy Lube, you can't go to another Jiffy Lube without violating an agreement of this kind. But it seems that there is enough data now to demonstrate that there is nothing good, nothing pro-competitive or about any of that for lower wage workers. And there are now, I think, 8 or 9 states that have begun to pass laws outlawing non-compete agreements, defining variously what constitutes a low wage worker, but that's what they're aiming for. That doesn't really address some of the larger issues among nurses, engineers, university professors, and people like that. But I think that there will ultimately be research that will demonstrate that those that, well, first, that it's unclear that there's any pro-competitive benefit to non-compete agreements at that level. And second, will demonstrate that there are less harmful options. And that would be a kind of a middle ground or requirement that a presumption be made that then has to be overcome by the company, by the employer. Things of that kind will move in that direction. And I think that sort of thing is probably within the realm of possibility for the Federal Trade Commission. I'd love to see it myself.
Yeah, it's interesting. I am unaware of any case or enforcement action that applies federal antitrust laws to employer-employee non-competes. I think it would be a wonderful test case. I think the economics is catching up to reality to the point where one could imagine a case like that. But for now, anyway, it's a patchwork of state employment law. California, as we just heard, has one approach sort of on one end of the spectrum. And every state has its own regime, usually statutory. And the courts have, of those states, have interpreted them. For instance, Texas is much more permissive of these kinds of non-compete agreements, which one could argue is perhaps one of the reasons why certain Silicon Valley companies have moved to Texas. Because if you're an employer, it's a pretty attractive proposition to be able to retain your employees without having to pay them more, but instead requiring them to sign non-compete agreements. And so one wonderful effect of these different state laboratories is that you have perfect experiments, really, where you can compare. You've mentioned some of those studies. Matthew Marks, for example, at MIT has done a lot of this work, testifying in front of Congress and publishing papers comparing economic activity in different states that have different regimes. And in one state, Michigan, I think you have even a before and after in one state where Michigan followed the California example, and you can see how the economy changed. And it's really wonderful. So The FTC is considering rulemaking in this area right now. The ABA and several other organizations have submitted comments to the FTC, and I think one national standard would be wonderful. Certainly from my perspective, that I think the California example has shown that not only does this benefit workers, but in the long run, it benefits everybody for more innovation, more economic activity. I'll just say from the employer side, what is the argument for these things? It's that you want to give employers, so they say, an incentive to train workers, to invest in their workers. And if they're going to spend all this money training and investing in their workers, they don't want them to just leave to found a company based largely on the same technology, perhaps, and compete. And so one response to this, and I think you mentioned perhaps other alternatives, is that there are other ways to protect legitimate interests, such as non-disclosure agreements, where if you really are working on trade secrets, not, I don't think making sandwiches really qualifies, but you're working for a high-tech company, you're learning trade secrets, you can sign non-disclosure agreements that are enforceable. You don't have to limit that person's job prospects in order to protect legitimate interests. And I hope the FTC is going to balance competing interests in that way and issue some national standards so that there isn't, what I think is a bit of a race to the bottom, where, if you're a state trying to attract companies to your state, you have an incentive to allow these kinds of agreements, which I think pretty clearly injure workers.
Okay, thank you. Well, we're running out of time a little bit here, so I do want to save some time for questions from the audience, including the Zoom audience. I've got a number of other questions to throw back at you if we don't have enough questions from the audience, but at the start, yes, why don't we
do you see more states passing favorable anti-non-compete statutes over the next few years, or is the FTC basically the only recourse right now? And then how does this all play out in the world of remote work, where more and more companies have employees throughout the whole country, and certainly not in their home state? I'm sure that complicates things too.
There was a lot there.
So 2 parts. It seems like the main recourse has been states updating their labor laws as opposed to the FTC or judicial decisions. What keeps more states from updating their labor laws? That's the first part. And the second part is how does all this play out in the world of remote work, where employees are spread throughout the country?
So what keeps more states from adopting these rules that California has and that Michigan and others are looking at?
Yeah, I think it's like California, North Dakota. I mean, there's Oklahoma. There are only a handful of states that have, prevent these non-competes right now.
I think traditionally, what has kept them from doing it is employer lobbying. There are and labor. I mean, organized labor has its own vehicle for dealing with this, but not organized labor does not really have the appropriate organizations to deal with this. And it has not been, it really, until recently, has sort of not come to the attention of the economic community or anyone else. There's always been the assumption that labor laws will take care of these. I think some of the, I mean, labor is obviously shifting into something in which services, high-level, diversified types of services and knowledge-based aspects of employment are changing things to some degree, and with that, the importance of people being able to have mobility is something that is greater value is being placed on it. And there have these several states have started the process now. I think, what is there? Illinois, Washington, New Hampshire, Maryland are the ones I know of that now at least have banned non-competes for lower wage workers. And I would expect that as they get more information about higher wage workers, they may also do that.
Well, and imagine that there's probably an offset. Some of these states are looking to woo companies. You mentioned Texas is, I think this is very much a selling point for Texas,
Yeah,
for companies.
The problem Texas will have with these employees is presumably the same one that the Route 128 companies. You remember Wang? That was one of the Route 128 companies that grew bigger and bigger and more diversified internally. Well, the Wang employees, if they wanted to go off and do something different, couldn't do it in that area. But if they moved to California, they could, because whatever it said in their employment agreement with Wang couldn't be enforced in California. Now, that will also be true of employees in Texas who want to move. They won't be able to do that if they stay in Texas or if they're in any other state that enforces, as a matter of policy, these agreements. They will have to go through a very significant period of doing something else for a year or 2 years until that expires. But if they come to California, they'll be fine.
And I think the second question was in this kind of remote economy that we have right now for workers, how do these rules, these non-competes apply when you're employer here and you've got employees in Wisconsin or Texas or vice versa?
This sounds like a great final exam question. Well, it's interesting. I mean, one thing that comes to mind where I think, California, again, is being a leader, is that it can be very, very confusing for employees, especially now, where, what state laws are you subject to, what is permitted, what isn't. A lot of employers, even in states like California that prohibit it, know that their employees likely will not hire lawyers, are not sophisticated in this area, and will put non-competes in the employment contract anyway. And it has a big effect on behavior, even though it's perhaps not enforceable in court. An employee is not going to go through the expense of having to defend their rights. And so it has the same effect, even in states where it's not enforced. And in California, I know this was, the product of a lot of work by a lot of people. It's a very interesting development in the legal ethics world, where I think there was an opinion, I think by the California State Bar, I don't know exactly where it came from, but that if you are a licensed attorney in California and you put a non-compete in an employment contract, you are violating legal ethics, and there can be a state bar complaint for that behavior. But to answer your question directly, I mean, it really is a state-by-state patchwork. And in terms of, I think the choice of law analysis beyond that, I think is a little beyond what I'm capable of at the moment.
And that is, I mean, traditionally, employment contracts are state law. Contract law in general is state law. Is state law developed, state law enforced. It's unclear where all that will go. I do think it's an interesting, one of the ethical questions that was mentioned is some of the studies that are beginning now are those as to our studies of employees and to the extent to which they are influenced. Are they afraid to accept another job or to seek another job? At least one study that was, I think, referred to in some testimony before the Federal Trade Commission, which is holding some very interesting hearings, is that of all the different demographics of workers who are discouraged from seeking new employment, the greatest discouragement seems to have been the greatest impact is Black women. So that should be a cautionary tale, I think, for all of us.
That's interesting. Then I'm going to take a question from the Zoom audience here. The question is, should the US and EU work together to establish common standards in this area? Now, with the role of the states here and the federal government, that may seem a little bit more complicated, but are there areas where that could be possible? And if so, where should that happen? Maybe, Alan, you want to try to tackle that?
There obviously is transatlantic cooperation between the DOJ and the FTC and the European Commission, now some of the national authorities, for substantive convergence. I think that'll actually be a pretty easy area for substantive convergence because I think everybody agrees on it. The question then is just how you enforce it, which is going to then be a very much national matter that is going to be impossible to converge on. The one interesting difference is that in the US, obviously, you have the potential for agreement violates antitrust laws to be criminal. With criminal sanctions, it's per se, and there's no justification. Most European countries, you don't have that. You do in a few, though. Ireland, Estonia have it criminalized. The UK obviously has criminals, so technically it could fall within the criminal laws again. So I would think that may well be another area where they would be looking for substantive convergence. I think part of it comes back then to the earlier question about, well, how does remote working change this? Because I think originally, most employment contracts, you were employed by somebody. If you were in France and you were working in France, you were employed by a company in France, right? It could be the subsidiary of a US company, but it was clear that you were working in the company's offices in France and so on, right? Same thing in California. If you worked in Silicon Valley, you were working for Google or Apple, you were working in Mountain View or in Cupertino. And it was clear that was a California contract. Now, of course, you have the problem that that French worker may have gone to Belgium or may have gone to Italy. Or may have gone to the Nevada side of Tahoe. That's something that we haven't figured out yet. I don't think anybody, most of that, I mean, this is just a temporary, people thought originally it was a one-off. We'll see what the new normal is going to be, but employment contracts, taxation, et cetera, is going to have to adapt. Do we, who taxes that employee, right? Belgium? Nevada, California, we don't really know yet. We're going to have some, who is then your employer? What's the governing law? We don't, we're going to have to figure all that stuff out. At the end of the day, though, I don't think that companies are really looking for too much convergence because they know that this is just one aspect. I'm thinking of setting up I'm a chip manufacturer. I want to set up a new fab site in Europe, for example. Where'd I go? The differences in labor law and productivity, in the language, in the environment, in the planning permission, et cetera, they all come into the equation. And, I think most countries actually they want some convergence, but not too much, because they need they need to respond. It's not just being competitive amongst jurisdictions, it's actually responding to your local situation. That's one of the things people often misunderstand about the EU, some of these tax cases. Different countries have different priorities, and therefore they set their tax as a result differently. They set their housing laws differently. They set their planning laws differently. We hear a lot about in Europe, inflation is taboo for Germany for historical reasons, therefore everything else has to adapt to a low inflation environment. Correct, but other countries have their own things. In Ireland, the preoccupation is job creation. And the research in Ireland shows that the highest rate of job creation comes when the percentage of the public sector in the overall GDP is 30%. Anything higher than that, you lose job creation. Therefore, you set your tax code, et cetera, accordingly to keep it there. You also minimize corporate tax, and you increase the individual tax. You still get the same tax take. That's fine, right? Belgium is a totally different situation. It's actually the richest country in Europe by accumulated net worth, not by income, but by net worth. So Belgium, the key is not taxing investment income, right? Et cetera. So the balance in the tax code between employee, corporate, and investment income is very different. Those are all perfectly legitimate preoccupations. Not just, part of it is being competitive, but part of it is just responding to your own unique circumstances. And I think we'll never get away from that. Potentially, nor should we, frankly, if we want the world to be a really interesting place.
One of the one of Margaret Vestager's predecessors, a Dutch woman named Neelie Kroes, came to the big annual ABA spring meeting with 3,000 antitrust lawyers, and was being challenged by, at that point, the U.S. viewed Europe as a kind of a renegade in antitrust, and why were they doing things so differently from the way it was being done in the U.S. Because the U.S., after all, had sort of created antitrust law, and she said, and the first words out of her mouth were that she had her marching orders from the commission, and those orders were that what was important was jobs and job creation. And this was complete heresy in the US at the time. I mean, there was a sort of an audible gasp when she said it. Those of us who were around at the time all remember it. It was really a remarkable thing. But one of the biggest problems, of course, with all of this is that antitrust is such a cumbersome way of dealing with this issue, which in California is simply done by a statement of labor policy. For example, if you have only a small number of people who have a non-compete clause, is that enough of an impact on competition writ large to rise to the level of an antitrust violation? And the answer is maybe not. Maybe it doesn't affect competition broadly enough to be a violation of the antitrust laws. And that may also relate to a problem that I'm sure Dean has with putting together a class of workers that's large enough to be said to affect competition broadly, but is not so large that it encounters the problems with class action certification these days of not having a sufficient sort of a common nucleus of fact and all the various manageability concerns. It remains, I would say, as an antitrust issue, a very difficult one.
Okay, I see we have another question. Any more from the audience? Oh, wow, we've got quite a few. We're running out of time. How about the multicolored shirt up front?
Thank you. Given this new, relatively recent economic understanding of market power in labor markets, and as explored by Eric Posner in How Antitrust Failed Workers, what do you think are the most promising new legal areas beyond non-competes and no-poach agreements?
Well, I think, those two areas are really where the action is at the moment. But I'll note, Eric Posner was recently hired by the Department of Justice. He's now a counsel to the Assistant Attorney General. So he's certainly in a position to implement some of his ideas. The other area I would mention is in merger review. It's a really interesting area that in some ways forces us to choose, sometimes, hypothetically. So for example, historically, if you're a large company and you want to buy another large company and you're trying to get that through the enforcement agencies, one of the arguments you would make is, well, there can be all these efficiencies. We're going to be so much leaner. It will cost us a lot less to make the same products, and those cost savings will flow to the consumer. There, you might say, well, there are all these redundancies between the two companies. We'll get rid of those. We'll be much more efficient. Well, a necessary part of that is you're going to lay off a lot of people. So a lot of people will lose their jobs. And for those that are remaining, perhaps there's less competition for their work and their wages will go down. Now, I think historically that was generally seen as a good thing from the perspective of the enforcement agencies. That would be a way to help sell a merger. Now that is shifting. That is shifting quite dramatically. I don't think there's been an example yet of a merger being denied unless on this basis alone. But it's certainly a concern of the agencies. And I think it's a question that is now being asked. When two companies are merging, what will happen to the workers? And prices may go down, but if wages are also going down, will that merger be approved? It's a tricky situation. And I think there's a lot of action going on in that area right now.
Said very briefly, I think you're exactly right. I think merger is exactly it. And fundamentally, it comes down to the question then of market power of an employer over the employees. And are we then going to see, in the same way that privacy has now become an antitrust theory of harm, are we going to see not only wages, but also other, employment benefits, your healthcare, your gym membership, whatever, your vacation time? Are they going to become antitrust theories of harm? My suspicion is yes, because we haven't yet had the case where the merger has been denied because of the impact on employees. But actually, the basis for blocking or challenging that merger is actually there. We've seen, for example, in supermarket mergers, the big theory of harm is actually the power, not of the consumer, the power over the farmers. Right? So if you are basically, you have market power as a supermarket, you can ratchet down the price of milk, eggs, meat, whatever from the farmers. That's been an antitrust theory of harm now for several decades. For example, the logical next step is, well, if you can do it over individual farmers who are in their capacity as self-employed, you can also do it over employees. So I think it'll come there. The one thing, and I don't have any particular hope that this is going to happen, is part of the reason why we're having this debate about antitrust now is because we have legislative paralysis and legislative cowardice in many cases in other places. The real solution to this is actually in the legislature. The same thing that we're now looking at antitrust as a solution to big tech, whatever the problem. People think that there's a problem with big tech. So what are we going to do about it? Well, we don't know. But with antitrust, it's the one area where people can actually do something about it. But it's really a poor substitute for well thought out legislation. And the fact that we don't have it tells you where we should really focus our efforts in trying to fix society.
Okay, thank you. I think with that, we've run out of time. I think we actually ran over time, but I think that's a great question and a really good response. I do agree with the panelists that mergers is really kind of an interesting new area. I think where we're at right now is already an interesting area, but it's going to potentially get even more dynamic and pretty crazy maybe. I'd point you to one recent decision, and that's the decision by the Department of Justice to block the Penguin merger with Simon & Schuster. Not quite on point in the sense that it's not dealing with employees or contractors per se that are working for the publishing houses. But a real core premise of this is the monopsony theory that we're really talking about today, and that's for publishing. So these are for authors, the right to, compete essentially for different authors' works and compensate them accordingly. So I think there are parallels maybe in this recent case. This is probably the only one I can think of that comes even remotely close to this. It's an interesting, challenging question. So again, thank you for hosting and for inviting us here. This has been a fun discussion.